Good morning, this is Attorney Malatest. I want to have a quick discussion about ADA and reasonable accommodations. And one of the questions we get a lot is, do I have to provide the information my employer is asking for? And in most scenarios, it's a yes. You have to give your employer sufficient information to make a decision as to your request for a reasonable accommodation. Your employer can force you to go to one of their doctors on their footing, on their bill, but they can still do that. You have to remember that the business can't put you behind a forklift. They can't put you doing in a dangerous position while you're going through this rehabilitation process or while you're working with this disability. So just be aware that if you break your leg and you bring in a doctor's note and you work in construction, you have to prove to your employer what you can do and what you can't do. And you have to get documentation of that. And your employer is going to ask questions. They're going to ask specific questions. Well, can he drive a forklift? Well, can he operate a truck? Well, can he operate this, or that? And these specific questions need to be answered. So work with them, give them answers within a reasonable amount of time, and just be aware that it's going to be an intensive process to get this reasonable accommodation approved. Also be aware that if it's a small company, they may not have to accommodate you. So I believe, let's take a look. Bear with me. Because I know that different ones, I know for general with the EEOC is 15. But if we take a look, it might be 20 under the ADA. And it's important to verify, so it's 15. So it's 15 as well. So if your company doesn't have 15 employees, they don't have to accommodate you. So if you work at Sally's Boutique and she's got 6 employees working for her, and you tell her that you can't effectively operate a cash register or do stock because you have essentially broken both your arms or something, there's no reasonable accommodation there. She can terminate your employment, and it won't be against the ADA because she doesn't have 15 employees. So just be aware that there's different issues as you navigate through this employment law on how to react and how to move forward with each and every step. Now, there's a lot of great small employers out there who would comply, and there's a lot who wouldn't. I mean, that's a bad example because you can't accommodate that anyway. But what I'm trying to say is that work with your employer to get the medical information to them. Don't throw a fit because they're asking questions. And I know a lot of people just are against letting their employer know anything. They're fighting everything, and it's not helpful. It's not going to be helpful for you if they rule against your reasonable accommodation. They may find cause to terminate you outside of that. Failure to respond within a reasonable time to a request for additional medical information is a terminable issue. So if you come in with a doctor's note that says light duty, and your employer's like, what does light duty mean? You work in construction. How can you do light duty? And if they ask you 20 questions to bring to your physician, then you answer those 20 questions. And if you have specific questions about what they're asking or what's going on, we can work together, and I'm happy to help clients do that and working through the ADA reasonable accommodation process. If you have any questions, contact my office, and I'm happy to sit down with you for a free consultation. Otherwise, everybody have a great day. And remember, just working with your employers and keeping everything in writing is 99% of the time the best practice for how to protect yourself and preserve your rights under the law. Thank you.